seal order of some kind that he was under that would prevent him from doing the customary witness disclosure that is commonplace, a commonplace right under 6E. In that regard, we've looked wherever we can. We've asked him where this order is. There is no sign of a seal order that would bear any relationship to his testimony. So there's the very real prospect that he's simply being untruthful about there being a seal order. The further aspect of this is that he asserted his Fifth Amendment privilege not to incriminate himself during the course of these proceedings. That, as a matter of law, requires that he have had a substantial and real risk of criminal prosecution when he made that assertion. So if an incoming FBI director has faced a time when he believed he had a substantial and real risk of criminal prosecution, it seems to me that it's pretty elementary that this committee, acting on his nomination to that office, should have some idea of what the crime would have been. If a witness asserts a Fifth Amendment privilege and then appears in another proceeding, like a civil proceeding, for instance, and does not testify because of that Fifth Amendment privilege, the jury in that case will be instructed by the judge that those jurors are allowed to draw the adverse inference that what he would have testified had he not pled the Fifth would be adverse to his interests, and he could be treated as having testified adversely to his interests, that the facts would be adverse. So if a court, a regular district court in a regular trial, can draw that adverse interest about what is behind a Fifth Amendment assertion, then damn, this committee ought to be able to draw that adverse inference dispelled by having this individual actually testify about it. If we want to do this in closed session, if we want to do this with some safeguards, all of that is fine. But you spoke very eloquently at the beginning of this, Mr. Chairman, about the importance of precedent. And I just want to mark right now that this is a first-time precedent in which a nominee for a senior law enforcement position in the United States of America has asserted a Fifth Amendment privilege about his own conduct and has testified in front of a grand jury, and the committee is being denied access either to the gravamen of his Fifth Amendment assertion or the content of his grand jury testimony. To me, that is an extremely dangerous and indeed even astonishing precedent. And I'll ask that the letter that we sent be put into the record.
Without objection, will be meetings adjourned.